that have to be taken in the next couple of months in order to prevent a situation where St. Martin can get another public statement. Today, the Minister of Justice will be giving an update on the implementation of the CFATF related laws. I do need to note that this morning within the faction leaders meeting, there were some faction leaders that had expressed the wish for it to be perhaps closed door. However, having conferred since then with several of the faction leaders, it seems that actually they believe that this should continue as an open meeting, which was the request of the minister as well. According to the rules of order, unless there's any objection to proceed with the meeting as scheduled, I will proceed with the meeting in open door fashion. Okay? So at this time, I would like to proceed to give the floor to the Minister of Justice, Mr. Egbert J. Duran, for any opening remarks on the topic, after which, within the Central Committee, other members of Parliament will have the opportunity for questions and comments as well. Honorable Minister, thank you very much for being here, and as mentioned, if you can also introduce your team to the members of Parliament and proceed with your opening remarks. You have the floor.
Thank you very much, Mr. Chairman. Good afternoon to you, to my honorable colleagues, members of Parliament, to my support team. Good afternoon to the people of St. Martin on a whole. On my extreme right, I have Ms. Lichia Stella. Then I have Mr. Vijay Yusia, the Secretary General, Mr. Russell Ursula, Ms. Ketura Brown, and Ms. Ruthmila Milton Gums. Mr. Chairman, I would like to go into some opening remarks to give a brief synopsis of where we are at right now. It is generally known that St. Martin is required under FATF recommendations promulgated to us that by the Caribbean Financial Action Task Force to implement those recommendations within a given time frame. Last year, we have been made clear that we defaulted in our compliance with those regulatory prescriptions. As such a result, we were issued a public statement in November of 2019. Immediately after the CFATF plenary session in November, St. Martin made an agreement with the Secretariat of the CFATF to assist us in trying to get rid of the public statement in the next plenary meeting of May 2020. St. Martin would have periodic video conferences, meetings with the CFATF Secretariat on a technical level. These technical meetings serve two purposes. They are to assist the CFATF in understanding the constitutional constellation of the Kingdom of the Netherlands and interpreting our kingdom regulations, jurisprudence, both of the Supreme Court, the Netherlands, the European Court of Human Rights, and, of course, the national laws in the context of the FATF standards, amongst others like recent amendments to our Penal Code and the revision of the Civil Code, Book 2. These legislative regulations, as you may know, were approved very late in 2019 by this same Parliament. With these periodic video conferences, St. Martin will also get pointers from the CFATF Secretariat on how to close certain gaps in the FATF recommendations in order to make St. Martin more acceptable in terms of compliance. St. Martin already had 3 productive meetings during which we were able to convince prove to the CFATF representatives that St. Martin had already closed certain gaps and thus live up to certain recommendations, almost to full some outstanding recommendations. St. Martin still has to deal with 2, which is recommendation 23 and 35. A 4th meeting with the CFATF Secretariat is scheduled for the 28th of February. We are awaiting some factual information from the Central Bank of Curaçao and St. Martin and the Civil Aviation Authority to pass through to the CFATF assessment. It is worth mentioning that the second video conference with the CFATF representatives, they inquired on handling the approval of the Penal Procedure Code, if this could be expected. Hopefully in March or latest, hopefully in the ending of March at latest, the CFATF Secretariat will internally discuss all information from St. Martin and will set up a draft report for the plenary session in May, of which the meeting of the CFATF will take place, and a decision based on us having a public statement will be made. Only in the plenary of 2020, the CFATF will decide on the application of the St. Martin to exit the third round and move to the fourth round of the mutual evaluation like Curacao and Aruba and all other CFATF member states. It is good to note that two laws that was passed here in Parliament and published late of last year were not recognized during the time when we receive a public statement. Of course, during our next evaluation, they will be taken into consideration because they were published, I believe it was 4 days prior to us having a plenary session in Antigua. And also to note that basically the purpose of me being here today is to get the views of this Parliament, because I had, as the chairman mentioned, I had a meeting with the outgoing Parliament about 3 weeks ago regarding this same legislation. I would like to know the views of this Parliament and if they see the need for amendments, and if so, what are the amendments, so we could have a clear path moving forward, so we can bring up our compliance as soon as possible. So, Mr. Chairman, with that being said, I look forward to hearing from the honorable members of Parliament.
Thank you, Minister Duran, for your opening remarks. As suggested by the Minister, I would like to turn to the members of Parliament for any questions, comments, concerns, or positions you may like to express. Any MPs wishing to take the floor at this time?
Mr. Chairman, it is exactly because of what I was fearing was going to happen is happening now. You're talking on the front row here of 4 new parliamentarians that have not followed in-depthly on what has happened. If, when the new Council of Ministers is sworn in, you're talking about another 3 ministers that might be added on, plus the other 2 sitting in the back, you're talking about 9 new faces that have to vote on a law that is crucial for the survivability of this country. I have read through various position papers from the government based on the Raad van Advies, and I'm trying to put them together. Is there a document where there are track changes made on the original document, what was changed to the new penal code for ordering? Because then we can see what we're talking about in changes. I read certain chapters, 16, 17, 18, they look like all new chapters. And if they are, do we understand how far-reaching powers we are giving to certain people? You know, I don't have a problem with justice, but I do have a serious problem with abuse of justice. I want to be clear on my position. I have been living it for 10 years. So I'm not going to make up no stories in here to make things look shiny when they're as scruffy can be. So I just need to understand what's really being presented. I see the term continuously een aanwijzing tot een terroristische misdaad. What does it mean? Because they are refusing to answer it. In the documentation I see, they're saying, oh, no, that was already, and we always accepted it. No, what did we accept? If we are trying to move forward, then let us say what we are moving forward to. That is one. I noticed, and again, I can only talk of what I have read thus far, Minister, because I don't have all the documents, I believe, in my possession yet. I noticed that the Crown Witness seems to be something that has garnered a lot of attention in the Hall of Parliament. And what I would like to see is when we write that, because there are a few terms that I need to get some clarity on today, when we talk about jurisprudence in the Supreme Court of the Netherlands and the Human Rights Court, they are very specific that they are talking about very specific type of criminal cases and specific type of crimes. Can we be enlightened to what those are really? Because if you just leave it open, that means it's open for interpretation by those enforcing it. And I want to at least make sure that we have these things in check, that we know what we are talking about, and we don't suddenly get laws for convenience. So we need to do something. We need a specific tool to use, and we're going to use the Crown Witness tool, for example, to get at something or someone that I need to get at. Because the Crown Witness tool is a very open-ended tool at this point in time. It's not restricted to specific situations. They are referring to jurisprudence, but we don't know which jurisprudence, because you could have put a footnote and specifically say which jurisprudence we were referring to, as the law normally does. I don't see that in there. Secondly, Mr. Chairman, through you to the Minister, I noticed we talk about eenvormigheid, especially when it comes to the law. But Aruba didn't sign this law. Aruba didn't sign on to this. So while you talk about how the Hof in Holland wants this and the Charter says this, Aruba didn't sign on to it. So my question is, how does the judge handle in Aruba? Does he have a different law book now? How does that work? Because we're using the eenvormigheid and the, I don't even know that word, how nice, how you call it, the concordancy, how you call it? The concordancy. Please, I'm new in this yet, so I'm trying to catch on to all the terms as fast as I can. And that's why I was really hoping it would have been a closed meeting, that, you know, you don't ask questions that might make people think different now on where we are. For me, it's, those things are unclear. I need some more clarity, Minister, and if you can give those to me, that would set me at ease when I'm asked to vote on such a law, that I understand what I'm committing the country to. The country is bigger than Bonkamper, but we shouldn't commit the country to something the country can't handle. We have seen when we have institutions that can do what they feel like. This morning we had a great example. The CFT decided they ain't coming. So done, clear, we ain't coming. And there's nothing we can do. And these are the people that decide if this country gets money, yes or no. So in that sense, I'm saying, before we give instruments to organizations that sometimes you get the impression in the country that they're above the law, that we can put them within the law brackets. That's all it is for me. No more, no less in that sense. That's, for now, that's it, Mr. Chairman.
Thank you, MP Bonkamper. Any other members of Parliament? MP Sarah Westcott Williams, you have the floor.
Thank you, Mr. Chairman, and a good afternoon to you, our Secretary General, my colleagues here in Parliament. Good afternoon and welcome to the Minister of Justice and his entourage. Mr. Chairman, this afternoon we are supposed to, according to the convocation, receive an update on the FATF, CFATF laws, legislation. That's the agenda point. The minister provided a brief elucidation, but it is somewhere midway the process, if I am to interpret where we are right now today. It's only at around the ending of March that the CFATF will decide where St. Martin is at. They will prepare a draft report. In the minister's last presentation on this subject to Parliament, he indicated a couple of things. One, he was in possession at the time of the comments, proposals for changes, concerns, etc. of the members of Parliament. And the ministry was busy seeing how to accommodate these concerns, the wishes, the proposals, etc. of Parliament. Because in addition to this meeting here this afternoon, which should have provided us with where do we stand right now today as far as it pertains to the handling of the Criminal Procedure Code. Where do we stand right now today? In the minister's last meeting, he did, as he has done today, indicate that in consultation with the CFATF, methods were being sought, arguments were being sought to prove that to a great extent already, without the Criminal Procedure Code, St. Martin is pretty far in its compliance. Has that point been established between the government and St. Martin, of St. Martin and the CFATF? Are we, now with the laws that have been ratified in December, not yet having the Criminal Procedure Code, has it been established with the CFATF that St. Martin, based on other legislation, based on other agreements, that St. Martin is pretty much at the end of the compliance trajectory? Yes or no? Is it yet to be determined whether without the Criminal Procedure Code we are pretty much at the end of that trajectory? Today we're supposed to get that update this afternoon, but there is in process a law presented by the government of St. Martin, namely the Criminal Procedure Code. Up until this moment, the Parliament and people of St. Martin have been told, and several functionaries have re-emphasized to the Parliament of St. Martin that this Criminal Procedure Code is a must. Is a must for CFATF compliance, which means it is a must for a new and more positive statement to be issued on St. Martin. Is the Criminal Procedure Code currently under discussion in Parliament still a must for a positive evaluation of St. Martin as far as the CFATF recommendations are concerned? Yes or no? Everything, in my opinion, turns around that particular question, because if that is no longer a must for compliance, then the Parliament of St. Martin has sufficient time to give a draft Criminal Procedure Code the scrutiny that such a law, such a code in our system deserves. So, as far as I'm concerned, up until now, with some of the members who are in here now and who have been in Parliament, there are quite some concerns, some proposals and suggestions on the table of the minister with respect to this law. So what the minister should be receiving now is, after having given the new members of Parliament the time to peruse this document, to hear then their concerns. But again, until now, everyone who has spoken, everyone in authority who has spoken to the members of Parliament on this topic has pleaded with the members of Parliament, have admonished in some cases the members of Parliament to do all within our power to pass as soon as possible the Criminal Procedure Code. Does the minister still subscribe to this urgency with this particular piece of law, or do we have sometimes some maneuvering space in order to handle the Criminal Procedure Code in-depthly as such a document should be handled? And secondly, the minister asks with respect to proposals. So my question to the minister, are you in, I know you are in possession, so let me rephrase that. Have you and your ministry been able to look at the proposed amendment that came from my hand, which is not touching on any of the articles of the Criminal Procedure Code? Let me make that very clear. What I am suggesting in the amendment to the Criminal Procedure Code is that as far as the implementation of that code is concerned, which has to happen by national ordinance on its own, that the government have some flexibility in terms of which parts of the Criminal Procedure Code go into effect when. That amendment is with the proposed amendment, mind you, is with the government. And my question is, what is the minister's view on that proposal, that in the ordinance with respect to the implementation of the Criminal Procedure Code, some flexibility is given with respect to the date of implementation of different parts and or articles in the Criminal Procedure Code. So as far as I'm concerned, Mr. Chairman, kind of turn it back to the Minister of Justice to receive responses to those questions. Thank you, Mr. Chairman.
Thank you, MP Westcott. We have next to speak MP Gums. You have the floor.
Thank you, Mr. Chairman, and good afternoon again, Minister, and your support staff. I think I don't want to echo my colleagues. My primary question would be, when you ask for proposals, amendments, I understand that there are some that have already been submitted to the ministry. What is the timeline for then if those amendments are approved to implement them? And secondary to that, how does that impact our approval timeline? Because as MP Westcott said, from the moment we even started this process of being sworn in, etc., we have been pre-admonished, I would say, by higher authorities that this is of extreme urgency. So I don't want to also feel like I am being made to rush to vote on something that could have very long-reaching consequences and implications for the people of St. Martin. So what is the timeline then hereafter from this meeting? That's all, Mr. Chairman. Thank you.
Thank you, MP Gums. Do we have any other MPs wishing to use the floor at this time? MP Samuel, you have the floor.
Thank you, Mr. Chairman. Mr. Chairman, I too, it's not so new, but the 20th of November does not lend, in terms of this piece of legislation, the same time of other colleagues who were there a year ago. However, I understood that we had the recommendations of the CFATF that we had to approve, and somehow pieces of the Criminal Procedure Code was merged together with the recommendation that we had to approve. And there was some members of Parliament that felt that if those two could be separated again, that it would be a better process to follow. I would like to hear from the Minister the situation on that specific idea. Secondly, Mr. Chairman, I have before me a public statement on St. Martin at the plenary session of the CFATF from November 27th, 2019. And it says, jurisdiction with strategic AML/CFT deficiencies that has not made sufficient progress in addressing the deficiencies. The CFATF calls on its members to consider the risk arising from the deficiencies associated with the jurisdictions as described below. And then they mention St. Martin. The CFATF recognizes the progress made by St. Martin to date in addressing the deficiencies identified in its mutual evaluation report. However, the CFATF is concerned by St. Martin's failure to address remaining deficiencies in its anti-money laundering and combating financing of terrorism regime after the high-level mission that visited the country on August 24, 2018.
and the plenary requirements to overcome such deficiencies by February 2019, which has not been achieved as verified at the CFATF May and November 2019's meeting. The CFATF urges St. Martin to immediately address the AML/CFT deficiencies, including bringing the necessary outstanding legislation into force and effect. And Mr. Chairman, when I read including bringing the necessary outstanding legislation, that means that Parliament is to pass a legislation. It also means that the CFATF is waiting on a legislation to be passed. And I say this because I also understand that it is the intention of St. Martin to show by way of policies, to show by way of custom, that St. Martin is living up to the recommendations for that is required by the CFATF. My question to the Minister and the panel is it the legislation that we have here, the Criminal Procedure Code, is this the legislation that is being referred to? That is my question. And the other question is, if this legislation is not passed, if it's not enforced, if it's not ratified, will the other strategy of the minister to come with the let's say jurisprudence, like the way we have been doing things, to indicate that we are living up to the recommendations? So the question would be, would that suffice, even though it is said that the CFATF is looking for a legislation to be passed by St. Martin? That's my point.
Thank you, MP Samuel. I now give the floor to MP Irian.
Good afternoon, Mr. Chairman. Good afternoon to you, the Minister of Justice, and his support staff. Some of my questions were already asked, but I would like to emphasize on the timeline and the urgency. I understand that we have a lot of new MPs in Parliament, and of course everyone should have the time to be able to peruse the law and go over it and so forth. But what I would like to know is, do we have the time? The urgency has been stressed by certain the business community, certain members in the councils. What I would like to know, how much time do we have, and what are the consequences? What are we facing? So we could weigh as a parliament on, okay, if we don't pass this law now, this is what we risk, and if we do, this is what we risk. There's a thing on both ends. There's something we are compromising on, but I'd like to know what the bigger factor is. Is de-risking a serious threat? Is that really a serious threat? Do we have examples in the region of this? I can see myself agreeing to the sentiment of, if we had time to separate the two laws, that we only approve the CAFTA. But again, the main question here is, to me, do we have time? What are the risks? And what are the possibilities? If so, amending the law, if we had to approve it, amending it after. If we had the time, if we know we want to amend, is it possible to approve and amend after? Yes, that'd be all, Mr. Chairman.
Thank you, MP Irian. Next, we have MP Grisha Heiliger. You have the floor.
Good afternoon, Mr. Chair, and Minister of Justice and your support staff. I, too, share the same sentiments with MP Bonkampa and MP Gums. I am not fully familiar with the CFATF law, so I have a few questions. As a newbie, as a newcomer, please bear with me through you, Mr. Chair. Oops. Here we go. Can the minister explain where these laws or these changes, where did they derive from? Where did it originate from? What was the initiation process? Did it come from the kingdom level, the civil servants level, governing program level? As I have yet to hear that part. How does it affect St. Martin's competitiveness? Why I ask this question is because recently we passed a law where everyone has to declare their personal jewelry, and that already is affecting us, and it's affecting our tourism base. So how does that affect St. Martin's competitiveness? Have islands like the Bahamas, I think MP Bonkamp already asked that, islands like the Bahamas, British Virgin Islands, St. Lucia, Nevis, Anguilla, have they already adopted these laws? If yet, please, can you show me and explain me what they have experienced? And is the minister aware that the former head of the central bank, Dr. Trump, he had a meeting with the U.S. Treasury to discuss these laws? If you're not aware, can you find out then what the outcome was and follow up on those conversations? How will this affect St. Martin? Now that the Brexit law has gone through, will this also affect how these laws are governed in our competing islands? And what does the penal code have to do with the CFATF laws? I feel like we're mixing apples and pears. I'm not sure, correct me if I'm wrong. And lastly, my last question to you, through Mr. Chair. Blacklisted, what does it mean for St. Martin? Has other countries been blacklisted? What are the ramifications? What does it mean for St. Martin to be blacklisted? I would like to know the details of that. Thank you, Mr. Chair.
Thank you, MP Heiliger. Next we have MP Sarah Lescott-Williams.
Thank you, Mr. Chairman, for the opportunity in this Central Committee meeting to get the opportunity to further elaborate on my questions, earlier questions to the Minister regarding our Criminal Procedure Code. Minister, on the 11th of December 2019, our number 409, so IS 409, you wrote to the Parliament inter alia the following in your letter. The letter having to do with your request to discuss the proposed draft penal procedure code for St. Martin, and at that time to postpone the meeting that we were supposed to have in December. You asked for it to be postponed. And you say in your letter the following: the mutual evaluation by the Caribbean Financial Action Task Force, CFATF, on St. Martin in 2012, with the report published in 2013, brought to light that some essential sections, and I need to get clarity on the following part of your letter, that some essential sections would need to be included in our penal procedure code in order for St. Martin to comply with international standards in the area of anti-money laundering and the combating of financing of terrorism. Is there a recommendation from the CFATF specifically to amend our criminal procedure code to include some of their recommendations, or are these recommendations exactly that, and the countries then decide how and where they deal with these recommendations? Recommendations such as, for example, know your clients, etc., by banks. And so these recommendations, I don't know if specifically the CFATF would advise a country, this has to take place in your criminal procedure code. But I will gladly hear from the minister if, based on his letter of December 2019, that the CFATF recommended that some essential sections needed to be included in our criminal procedure code in particular in order for St. Martin to comply. So that's one additional question. The minister in the same letter talks about what colleague Boncamper referred to, and that it is the uniformity of these laws. And the minister informed Parliament in December that it would not be possible, in his view, to have this uniformity in time for the May evaluation. And then, Minister, you told the Parliament in December in that same letter, and now I quote again, noting the above, the uniformity, etc., I, the minister, will embark on an exercise to explore whether St. Martin is able to adopt alternative legal measures or provisions which would temporarily fill the gap for these international standards needed to be in place by May 2020. The intention would be to afterwards finalize the Penal Procedure Code with insertion of these relevant sections. Minister, the exercise that you embarked on, that I just mentioned, what are the results of that exercise to see if alternative legal measures or provisions could be established according to your letter to the Parliament of St. Martin? And then you conclude by asking for the meeting which was scheduled for Thursday, December the 12th, to be postponed until you had those explorations or exploratory talks done. So those are my two questions regarding to your letter to the Parliament of St. Martin. And then, Minister, is the ministry aware of any financial institutions on St. Martin, banks in particular, refusing to open new account activities, even with existing clients, based on the fact that this piece of legislation has not been passed by Parliament, and that one or more institutions have informed their clients specifically that the reason why no new accounts are being opened is because the Parliament of St. Martin, the legislative body of St. Martin, has not dealt with the Criminal Procedure Code that should enact some recommendations from the CFATF. Is the minister aware of this type of communication to persons on St. Martin seeking to establish a new account at one or more of the local banks on St. Martin? Thank you, Mr. Chairman.
Thank you, MP Westcott Williams. We have MP Boncamper next. You have the floor.
Thank you, Mr. Chairman. Through you to the Minister. I just have two additional questions. One is just for more, for clarification purposes for me. Which other countries within the kingdom have complied with the FACTA laws by changing their penal code, the procedure? Which other country has done that? And if so, yeah. No, the CFAT, sorry. Thanks for the correction, but that other people understand correctly. Which other countries within the kingdom have changed their criminal procedure code to comply? That's one. Two, the crux of changing this law was to prevent, it is very nicely written, it was to prevent illicit misuse of your country's financial system. We don't do offshore companies anymore. We don't do offshore banking anymore. So what exactly is it? Because all UBOs, the ultimate beneficiary owners, are known by the notary. You have to give it up there, and when you open a bank account, you give the name of the owners of the NV, the BVs, or whatever. All that information, you use Article 177, I believe it was, because that's the one they used on me, to go and ask what I have on my bank account. So they have the information. They can get it at this point in time with the AFPAC team, the TBO, the RSC. All of these people have access to the information already. So why are we now changing the penal code to facilitate the CFATF if it already exists and is being used? I noticed they use the word, they want to code it. If you want to code something, that means it's being used all the time because there's jurisprudence on it. Then I have asked, like I asked in the beginning, please facilitate us with the jurisprudence. Then we can at least judge if we are not on a fishing expedition in this law, but that we are genuinely trying to bring something to the country that is in the best interest of the country. Thank you, Mr. Chairman.
Thank you, MP Bonkamper and MP Gums. You wish the floor once again? You have the floor.
Thank you, Mr. Chairman. Minister, I just have one more question, and it's possibly just for future preparatory reasons. In my experience in my professional career, I've worked for a trust company that had to adhere to many regulations such as this, and pending FATCA laws as well. As I understand it, for a country, even when it comes to the UBO, were there any other recommendations coming from CFATF, or can we expect that they recommend or another body recommends that we establish, for example, a gaming board? Because it's not just offshore banking, as we know, that has its purview in money laundering. So that is something that I would like to ask to you, through you, Mr. Chairman, to the Minister. Is there anything else that we can expect coming from CFATF along the lines of establishing, for example, a gaming authority? Thank you.
Thank you, MP Gums. MP Samuel? MP Samuel, you have the floor.
Thank you, Mr. Chairman. Mr. Chairman, I understand from the Minister that we are still in round 3. And my question is, if we had everything up to date, where would we be at this moment? And what do we have to do in order to be in line with everybody? So let us say that if everybody is on round 4, what else do we have to do in order to be up to date? Because St. Martin seems to have a little backlog, and if we were to work the backlog, what all do we need to do in order to be up to date, to work away the backlog for St. Martin? Thank you.
Thank you, MP Samuel. Any other members at this time? I don't see any need. Minister, before giving you the floor to respond, I do have a couple points, as this is a central committee, I would like to add. But before doing that, Minister, I would like to say and actually thank you for taking the bull by the horns when it comes to this issue, to use that term, and not shying away from the fact that it is quite a challenge to say we are going to, as was expressed, for example, by MP Arian, we have a time situation. But I, for one, am cognizant of the fact that this is not a time situation that was created today or last week or last month. I remember from since when I swore in as a member of Parliament April 2nd of 2018, the week after that, we already had our first meeting in which this topic was brought to the members of Parliament. And it is only now, and I would say, in my opinion, the assessment you gave in just the 10 minutes that you spoke has shown me more progress than I've seen in the last 2 years. So for that, Minister, I want to take a moment to tell you, thank you for the open update on that. And I think that it is something commendable to see that, although it's a tricky subject and a very divisive one that it's been in the past, you haven't shown any kind of sentiment where you're not willing to address it head on, and that is commendable. Minister, I also do want to point out something else, and which might also help. Indeed, maybe what might help is a bit of a timeline. If you can give us when were we first, and it doesn't have to be very long, from when in St. Martin's history were we notified that this is an issue? Can you explain that to the members of Parliament so we understand that this is, again, it's not something, maybe we've come to the cusp of where we are now, that, okay, now that it's risk of blacklisting, suddenly we're being pressured or admonished, and that type of language is being used. But how long have we known as a country that we are supposed to live up to these issues? Because, especially for new members of Parliament, I think it's important to know our history to understand that we do not repeat the mistakes of the past. So that when the warning signs of maybe things that we have to comply, for example, in 2024 with the FATF, that we're taking that also by the horns now as well, so that we don't repeat the mistakes of the past, where it was simply kick the can down the road, and now that we think it's grey listing and so on, we want to say the minister need to pass and bring the code and all of this. But let's see if we can have a timeline on how long we knew about this and what other pending matters going forward that you at least want to have us keep in mind. Minister, I would also like to understand, in any sort of handover between the previous minister and yourself, was there any explanation given as to why this was not handled before, or what efforts were made by the previous minister to ensure that we could have gotten this done? Because again, I think it's important to put that context so we understand if there was room to actually make amendments to it, why was that not possible, and does that room still exist today? Another point I just also want to bring up, and this is a document that we received from the minister at the time, and it was on a question that I posed, and I wrote to the minister. I wanted to see very specifically from the Penal Procedure Code, these are the recommendations of the FATF in one column, and I want to see if you correspond that to the Penal Procedure Code, what specifically is in there that we're saying we need to adjust this penal code. And I kind of got the answer, so to speak, from MP Boncampo. Although he says he's new, I think he hit the nail on the head. A lot of the things that is being requested is already being practiced. For example, when we talk about recommendation number 4, confiscation and provisional measures. See also recommendation number 38. Well, Minister, we know of those situations existing today. We have a TBO, we have AFPAC team, and so on. Is that something that we are applying and showing to the FATF, where you're now saying, well, we've come from, in the space of months, from complying with 0 recommendations to now, correct me if I'm wrong, basically 2 recommendations that are still in question. Then you have 30, responsibilities of law enforcement and investigative authority and powers of law enforcement and investigative authorities. In terms of that, is the Criminal Procedure Code really the only instrument to comply with 30 and 31? So you get my point. And this document was shared with all members of Parliament so we can more clearly see not just what has to be done, but why it would have to be done and why those article points to those specific recommendations. So, Minister, if we can get also, just to clarify once again, you were mentioning in your opening statement with regards to the progress being made, because although you have a meeting, let's say you had it in Antigua, it appears that it's not just you meet with them, there is a continual process of you engaging with them, and that can also affect the sentiment. So based on that, the next meeting, can you just clarify when that would be? And I think that would be an important point. If it's very soon, that soon after that you can maybe give us an even better update on, okay, where are we now with the progress you've made? Other than that, Minister, again, thanks for the update that you've given. We have received various questions from the members of Parliament. I will adjourn for 2 minutes to caucus with the Minister on the way forward for this meeting. Meeting adjourned.